Commonwealth versus Fuentes.
Oh, I thought Fuentes was on.
Mr. Keene, you have 10 minutes. You may proceed.
Thank you, Your Honor. Benjamin Keene, Committee for Public Counsel Services, on behalf of Jose Fuentes, and with me at table is Mr. Fuentes' trial counsel, Attorney Jason Thomas. This is an appeal from the denial of the defendant's 211-3 petition, which sought relief from the denial of his motion to dismiss on double jeopardy grounds. If I could just take a minute and a half of my time, I think it's important to sketch the factual and procedural posture in which this mistrial was declared. The defendant stood trial for a distribution of heroin. He was alleged to have sold some heroin to an undercover police officer. The defendant was arrested about 40 minutes after the sale. He did not have on his possession either the buy money that the undercover officer used or any drugs, and the defense was misidentification. The jury was obviously struggling with the evidence. During the second day of jury deliberation, there were three questions that the jury proposed, or three communications that the jury brought to the judge's attention. The first, a question of law, which the judge properly brought to the party's attention, and it was answered to the jury's satisfaction, apparently. There was a second question, which was, at what point is a jury hung? At this point, the parties were informed of the content of this note. The parties treated it as a report of a deadlock.
Mr. Keene, is there any requirement that the court consult with defense counsel prior to dismissing a jury that's deadlocked?
Yes, absolutely. The Stewart case makes that absolutely explicit. That was decided 22 years ago, not cited by the judge in her motion to dismiss. It says counsel must be given full opportunity to be heard, and two, the trial judge must give careful consideration to alternatives to a mistrial.
Yes, when there are situations other than a deadlocked jury, but does Stewart address a deadlocked jury situation?
The facts in Stewart do not involve a deadlocked jury.
That's what I mean. I understand that when the mistrials can be caused by all sorts of circumstances, but in these circumstances, it's the defendant's position that the Stewart principles, and they're described as principles for dealing with declaration of mistrials, not accept those mistrials that may be the result of a hung jury, requires notice and an opportunity to be heard. But what alternative is there in the face of the statute?
The alternative, and this is what the key is to this case, why this is, I think, when you look at it, actually quite a simple case. The alternative is in the statute itself. It says that a jury which has twice reported deadlock, cannot be forced to continue deliberating, but may agree to do so if they agree, if they consent, if they ask. And at the judge, and what this case really comes down to is the judge's erroneous belief that she lacked any discretion but to declare a mistrial. She said at the time let me just paint the picture because I think it's important. When the third note comes, which is the second report of a deadlock, defense counsel does not see that note. The parties don't see that note. They are summoned, defense counsel is summoned.
How much time passed between the second note and the third note?
I believe it's about an hour and a half. About an hour and a half. I could be a little wrong on that, but it's in the same morning of the second day of deliberation.
What do you do? What do you do if you ask the jury, will further discussions help, and 10 people say no and 2 say yes?
Well, that would be an interesting case. I don't know what we would do with that. But
have you ever seen a situation in which the judge first asked the jury?
Yes, I looked all over. I found they're collected on page 11 or 13 of my brief. I can't remember. All the mistrial cases in Massachusetts involving hung juries. Every time in the reported decisions, there is an on-the-record colloquy between the judge and the jury or the foreperson. Are you, in fact, deadlocked, or would you agree to deliberate further, as in the Jenkins case? So, yes, The judges, in fact, have discretion. I don't know what would happen if they didn't exercise it, knowing they had it, but they routinely do, in fact, exercise their discretion under Chapter 234, Section 34, to ask a jury whether they would consent to deliberate further. It is black-letter law that a judge who erroneously believes that she lacks discretion about a matter has committed an error of law. And that is what this judge do. She says, after she summons the parties, defense counsel doesn't know what the content of the third note is. She reads the note. We, the jury, are unable to come to a unanimous decision. So I have no choice. This is on page 32 of the record appendix. So I have no choice but to declare a hung jury. She goes on and excuses the jury. They're gone into the coat room. Defense counsel, respectfully, Your Honor, I didn't know what the jury was going to come back with and say that they weren't able to come to a verdict. I believe in this situation. This is the objection that is characterized as a formal or a pro forma objection. I believe in this situation that General Laws Chapter 234, Section 34 applies, that when a jury comes back a second time, the judge cannot force them to go back out, but they can go back out if they themselves consent. The case law in mistrial declaration area is absolutely uniform. The judge must consider all plausible alternatives. The judge here, believing she had no choice under the statute but to dismiss the jury as deadlocked, did not do what any reasonable judge might have done. Ask the jurors, notwithstanding this second report of a deadlock, are you nonetheless, is there any plausible probability of reaching a unanimous verdict? The jury might have said yes. Both the Commonwealth and the single justice said that they concede, it's significant, that this was error. The Commonwealth concedes that it was error. This is on page 16 of the Commonwealth's brief. It would have been better practice for the judge to have inquired whether the jury wished to continue deliberating. But they argued that it was harmless beyond a reasonable doubt. I submit that that standard cannot be met here. If the jury had been asked whether they would agree to continue deliberating, notwithstanding their apparent deadlock, they might have agreed to do so. How can that possibility be excluded beyond a reasonable doubt? Had the jury agreed to continue deliberating, they might have reached a unanimous verdict, thus terminating jeopardy. So that's why the law is clear that where there is an available alternative to the declaration of a mistrial, and here there was, asking the juror before the mistrial is declared.
Just for clarification, the third note from the jury foreman said that we are unable to reach a unanimous decision.
Correct. And that's reproduced in the record appendix. And where there is an available alternative, and there was, they could have asked the jury to agree to continue deliberating, as counsel pointed out at the time. And the judge fails to adequately consider it. A declaration of a mistrial cannot stand. It is a double jeopardy bar to retrial. This case is, in this light, very similar to a host of cases, which I've cited in the brief, in which retrials are barred, not on hung jury grounds. I grant it, your question is apt on this point, but on a host of other grounds where there was a plausible alternative to the declaration of a mistrial, but the judge, often mistakenly believing, as this judge did, that a mistrial was somehow required as a matter of law, did not consider it. The Horrigan case is a case in which the judge is sick. The chief judge comes in the next day and says, I'm sorry, the law requires that I declare a mistrial. Justice Kaplan, in the Horrigan decision, explains why this erroneous belief by the judge that he had to declare a mistrial is the analytical flaw in the thinking of the judge, which triggers the double jeopardy violation. So those are the cases that I believe this case really falls under. And to reiterate, it's a familiar rule, and it's quite stark, where the judge says, "I have no choice but to declare a hung jury." She's mistaken about that. And even, this is my final point, even when she denies the defendant's motion to dismiss, this is a week or so later, in writing, nothing in her written motion, in her written decision, evinces any awareness that the statute permitted her to ask the jury if they would nonetheless consent to further deliberations.
Thank you, Mr. Keene.
Thank you.
Ms. Dillon?
Good morning, Your Honors. Even if Chapter 234, Section 34, permitted her to ask whether or not the jury would consent, there's no law that required her to ask. What we're talking about is an abuse of discretion on two different levels. First of all, did the single justice abuse his discretion in denying the petition for 211-3, and he determined that the judge did not abuse her discretion in declaring a mistrial. Once the jury had reported for a second time, and he now concedes this was a second time, that they couldn't arrive at a verdict, Chapter 234-34 requires that they can't be sent out again unless they consent. Now, in this particular case, Cassidy says that if he didn't come up with a suggestion for the judge at the time, this court will not reverse what happened at the time. That jury was still intact. They hadn't been exposed to any other extraneous influences. If trial counsel wanted the judge to ask if they were willing to consent to deliberate further, it could have been done.
But I thought trial counsel did. First of all, trial counsel didn't know what the note was, and then he raises the 234, Section 34.
Yes, sir.
And what is she, I mean...
He said, 234 says this, you could ask, note my objection for the record. That's all he said, note my objection for the record. He never asked her to do anything. And I would suggest to you...
Did he raise 234, Section 34?
He mentioned it, yes. But he didn't ask her to do anything. He didn't say anything about that. But the point is, and if you look at her findings, she said, based on what she observed of the jury, it was clear to her that they were not going to agree. And if you look at some other case law, this...
Do you agree that that one way to read her statements is that she didn't believe she had any discretion?
I think that's an overstatement of the case. She said that based on her... I don't know how many times you've seen a jury come back in when they can't agree. Sometimes you wonder what's going on back there, and you worry a little for their safety. I mean, I admire jurors' candor from the moment of empanelment until the end. But when she said in her findings that it was clear to her, based on the deliberations, it's 3 questions and, 4 hours or something of that nature, the very short nature of the case, and what she observed of those jurors, it was clear to her that they were not going to be able to agree. There are no alternatives.
So but fundamentally, Ms. Dillon, as I understand it, you take issue with the defendant's position that there is a requirement. Now, maybe the judge can meet the requirement on this record by saying you have to consult with counsel, or, she decided because he didn't, ask her to do anything. But there's no requirement?
There's no law in this Commonwealth that I can find that says that the judge is required to ask. And in fact, Thames says that she's not required to get the assent of the defendant. Cassidy says that if the defense attorney didn't ask for it, this court won't impose it. And above all, we're dealing with an abuse of discretion on both levels, whether the single justice committed an abuse of discretion and whether the trial court committed an abuse of discretion. And I would submit to you on this record that neither judge committed an abuse of discretion and there is no error of law.
Thank you, Ms. Dillon.